The language of law is complex, critical, and not easily understandable by ordinary people. Law is changing day by day. Law is a social control. It has a primary aim of social welfare. It is an instrument of social change. It assumes importance in India from the point of view of legal education, namely people trained in law and ethically equipped to render services not only to the literate and rich, but also to the illiterate and the poor. After the British rule was started by the East India Company, the legal profession was also started. Gradually, the Western civilization, culture, education, administration of justice systems, which were introduced in India, substituted the centuries-old age Hindu dharmashastras and Puranic injunction and amended them to suit the changing times. Legal education and development have become interrelated in a modern state. Amongst us, legal education speeded nationalism. Our country produced great lawyers like Motilal Nehru, Jawaharlal Nehru, Mahatma Gandhi, M.C. Satalwar, M.C. Chagla, and many others. In fact, the legal education changed the Indian political and administrative setup. East India Company introduced the British system of judicial court proceedings from the very beginning in 1600. Charters of 1726 and 1753 established the Mayor's Court. The Supreme Court at Calcutta was established in 1774 by the Regulation Act of 1773. The Governor Generals of the time introduced several judicial reforms where there were no Indian trained lawyers other than barristers that came from London, as there was then no legal education in India. Only rich people could avail the legal services of barristers. There was a great need of Indian advocates. Law courses were started in 1885. The Hindu College in Calcutta, Elphinstone College in Mumbai and Madras introduced law courses in 1885 for the first time. Up to the 19th century, only males were allowed to study law courses. In the beginning of 20th century, ladies began to study legal courses in India. The legal education in the country took off after 1947. The wider scope of getting employment in the fields such as legal advisors in industries, cheat funds, finance companies, press, legal practitioners, judges, teachers in law colleges, administrators were filled to legal education. The number of colleges started growing after 1947. The Constitution of India has been the basic pillar for promoting legal education. The University Education Commission was established in 1948. The Commission gave its recommendation on legal education, and All India Bar Committee was established in 1951 with the aim and object of inquiring the defects in legal profession. Amongst other things, it recommended for a uniform qualification for admission to the role of advocates that it ought to be a law degree after attending a certain percentage of lectures for imparting education during apprentice course. It also recommended a legal education committee. The All India Bar Council was constituted to give recommendations for improvement in legal education. The first law commission was constituted in 1955. The commission was entrusted with the works pertaining to all fields of law. The first law commission recommended and suggested recommendations for development of legal education. Based on the report of All India Bar Committee, the Advocates Act 1951 has been enacted. Much waters have flown in the legal education system after 1985. With the advent of law universities, the first one being the National Law School of India University, we have the privilege of having Dr. Krishna Swamy with us, the President Vice Chancellor, and the past Vice Chancellor, Dr. Rao, who still has stamina to contribute more and more to our legal system. I think I have exceeded my welcome brief. Pardon me, Honorable Chairperson, condone my action and I wind here, giving you the platform, sir, to tell us where is the legal education going and tell us the way forward. Where besides the legal fraternity here, principals and faculty members of state colleges who I am sure will take adequate views from today's discussion. Thank you.
Thank you, sir, for your welcome and the eye-opener, as if I can say. I request our member Ryan Menezes to now formally introduce our speakers to this august gathering. Right?
Good evening, ladies and gentlemen. We have with us today a galaxy of speakers who come with a treasure of both knowledge and experience in law, who have graciously taken the time out on this weekend to share their wisdom and their perspectives with us. It is my privilege to introduce these eminent speakers to you today. Our first speaker, Justice Abhay Oak. He graduated with a degree in law and was enrolled as an advocate in June 1983. He practiced law at the Bombay High Court from 1983 onwards, appearing in several important matters in a range of areas, till his elevation as a judge of the Bombay High Court in August 2003. In May 2019, Justice Oak was elevated as the Chief Justice of the High Court at Karnataka, and on August 2021, he was elevated to the Supreme Court of India. May I request the President, Mr. Goyal Pereira, to escort Justice Oak to the dais. Thank you, sir. Justice Mahesh Sonak, a lawyer practicing at the Goa Bar, was enrolled as an advocate in 1988 and practiced at Goa in a variety of areas: civil law, constitutional law, labor and service, environmental law, commercial and tax law, company law, and so on. He has practiced both as a private advocate and as a standing counsel for the central government, special government counsel for the state government, and as counsel for statutory corporations. He was elevated as a judge of the High Court in 2013 and currently serves as the senior administrative judge of the Goa bench. May I request Mr. Shailen Bobe to escort Justice Sonak to the dais. Graduated in law and was enrolled as a lawyer in 1991. From then, he practiced at the Bombay bench of the Bombay High Court in civil law, criminal law, labor, service, and constitutional matters. He was engaged as a senior counsel group to represent the government of India and also represented the High Court administration from April 2009 till his elevation in 2016. He presently serves as a judge at the principal bench of the Bombay High Court. May I request Mr. Gauri Shabni to escort Justice Shabni to the dais. Advocate Devidas Pangam, the Advocate General for the state of Goa, has a practice of more than 25 years at the Goa bench of the Bombay High Court in a range of matters: constitution, anti-defection law, service, mining, taxation, environmental law. He has, in the course of his private practice and as Advocate General, appeared in many important cases and has brought forth many landmark judgments, several of which have been reported. As Advocate General for about the last 2 years, he has ably represented the cause of the government of Goa. May I request Advocate Nigel Costa-Priest to kindly escort Mr. Pangam to the dais. Professor Dr. R. Venkata Rao is currently the Vice Chancellor of Euler at Sankoi, Goa. A stellar career, he holds a BA, MA, ML, PhD and LLD honoris causa. He has served as Vice Chancellor of the National Law School of India University, of the Vivekananda School of Law and Legal Studies, the Vivekananda School of English Studies, and as he joined Euler in 2023 as Director Consultant and assumed office as its Vice Chancellor in March 2023. He served on the statutory body of several law schools and on the Board of Governors of the Indian Institute of Corporate Affairs. He's been a visiting professor at several institutions, has 10 endowment lectures, 8 convocation addresses, and several other honors which include a gold medal for the best PhD thesis from Andhra University in 1993, the Best Researcher Award from Andhra University in 2003, the Best Teacher Award from the Government of Andhra Pradesh in 2006, the Best Vice Chancellor Award for Outstanding Contribution to Education during the World Chancellors and Vice Chancellors Congress 2014. He has authored 6 books and more than 130 papers. He's guided 3 LLD candidates and up to 19 PhD candidates. He was also the chairperson of the Board of Governors for the Asian Law Institute. May I request Mr. Ram Livankar to escort Dr. Rao to the dais. Dr. Sudhir Krishnaswamy holds a Bachelor of Arts in Law from the National Law School of India University, a Bachelor of Civil Law from Oxford University, and a Doctor of Philosophy in Law from Oxford University. He currently holds office as the Vice Chancellor of the National Law School of India University and is the Director of the Department of Professional and Continuing Education at NLSIU. He is also the co-founder and trustee of the not-for-profit research trust Center for Law and Policy Research. Previously, he was director of the School of Policy and Governance and professor of Law and Politics at Azim Premji University and has been a Rhodes Scholar and graduate of the Oxford University. His areas of interest include constitutional law, legal system reform, legal theory, intellectual property law, administrative law, and he has written on a wide range of topics. He has several publications to his credit in the area of law. May I request Mr. Sudhir Usgaonkar to escort Dr. Krishnaswamy to the dais. Justice Oak, may I now hand over the stage to you.
My dear friends and esteemed colleagues from Bombay High Court, this is Mahesh Sonak, this is Makan Kani, Mr. Devidas Pangam, Advocate General of State of Goa, Dr. R. Venkata Rao, and Dr. Sudhir Krishnaswamy, Mr. Koilo Pereira, President of the Bar, Mr. Agni and other office bearers, very distinguished senior members of the bar and other members of the bar who are present amongst us, academicians and students. I must really compliment Goa High Court Bar Association for taking this initiative. I must confess that I am here as a member of the legal fraternity or somebody who is part of the legal fraternity for 40 years, 20 years as a lawyer and 20 years as a judge. But I am not an academician, and therefore I have my own limitations when I address you on this subject. Legal education in India has seen drastic changes from 80s. I joined law college, the government law college in Mumbai, which is the oldest law college in India, in 1980. The law education in those days was completely different. The law course was understood only to be a part-time course where we used to have maximum 2 lectures in a day. There were no extracurricular activities. If I remember correctly, I was sharing this with my colleagues today in the afternoon when I was here. We used to have maximum 1 moot court competition throughout the year. In fact, I must confess that in those days, it was very often said that those who cannot secure admission to any other better courses, for them law used to be the last resort. I must hasten to add that I was not one of them, but that was the fact. In fact, I remember my friends and colleagues in government law college. There were hardly few who had decided to practice law. We had retired government employees who wanted to do something after retirement. I had many colleagues and friends who were doing chartered accountancy or cost accountancy or company secretary course, and they were there as an additional qualification. I want to tell for the benefit of young students who are present here that I remember my days in government law college where we used to have only 2 lectures in the morning, and we used to spend our rest of the day at 3 interesting places nearby. One was of course Bombay High Court, and I was privileged in those days to see H.M. Siroi addressing a full bench. Hardly anything I could understand as a lawyer. The second best place was British Council Law Library, British Council Library, which was very close by. And third, and perhaps more interesting, was Wankhede Stadium, where we could spend 2 rupees and see Gavaskar and Vishwanath in action in Ranji Trophy or Dilip Trophy. Thereafter, the things started changing, and I must say, as the President said, that the first change was in 1986. That was with the establishment of National Law School at Bangalore, and we must all give credit to Professor Madhava Menon, who really changed the course of legal education in our country. I mean, so much can be said about National Law School in Bangalore, and I think National Law School Bangalore was the first university to start 5 years course, subject to correction, in 1988. Till 1988, all courses were part-time 3 years courses. And today, we are fortunate to have one ex-Vice Chancellor and present Vice Chancellor who have continued the old and grand traditions of Professor Madhava Menon. Advent of national law schools gave a different dimension to the legal education in India. And after national law schools started, 5 years course, then there are so many law colleges, leading law colleges, they started 5 years course. Till 80s, even thinking of having a full-time course in law was unheard of. I remember in those days, members of the Bar Council used to vehemently oppose any change in the law course. Even the full-time course was being vehemently opposed because their contention was that it will prevent common man from taking legal education. But fortunately, things changed, and I can say that from late 80s, the talent started coming back to the law. Because suddenly, you will find from late 1980 or early 90s that in leading cities of our country, legal profession became most lucrative profession. And perhaps that was one reason why talent started coming back to law, and now we have those competitive examinations like CLAT, or all states have their entrance examinations which are very, very competitive. And today we have large number of colleges, large number of law colleges, private law schools which we see today. Now we are talking about legal education in future. Now there are several issues associated with the legal education, and it is for the academicians to look into it. Though I am not an academician, I got a chance to somehow deal with legal education. I was associated with Maharashtra National Law School in Mumbai. Now in my capacity as Chancellor of MLLG Aurangabad. I am associated with the law education, and therefore I see number of difficulties. Now the first and foremost issues which we have to deal with in future is about availability of trained law teachers. We have 2018 regulations of University Grants Commission. The regulations provide that for even assistant professor, you need a master's degree with 55% marks, and you require that net set qualification, state level or national level entrance test or PhD. For associate professors and for professors, same qualification with some addition. So today, nobody can teach in a law school or law college unless he has a master's degree with 55% marks and net set or PhD. The result is, you take case of several national law schools, you take a case of several law colleges, you will find that there is a dearth of teachers. All law schools and law colleges are appointing retired people or those who are not qualified on contract basis. This is one area where perhaps the academicians will have to apply their mind. As a student of law, for their benefit, I want to say something. For becoming a good law teacher, is it necessary to have postgraduate degree? I'll give you an example. I am told that late Mr. Nani Palkiwala, Justice Chandrachud, Senior Chandrachud, and many distinguished lawyers were part-time lecturers in government law college. When I was in government law college, perhaps these regulations were not there. We had very senior and distinguished members of the bar who were working as part-time professors. Now, mind you, Senior Justice Chandrachud and Mr. Nani Palkiwala, arguably one of the greatest lawyers India has produced. All of them had only one law degree, that also 2 year old. In those days, there were 2 year LLB course. Can we say that they were not competent to teach law? Today, when I was a law student, so many members of the bar, those who were practicing in City Civil Court in Mumbai, those who were practicing in High Court, they were very distinguished members of the bar. All of them were teachers, and we were immensely benefited by their presence. Therefore, in every conference of Bar Council which I attend, I always tell the Bar Council that, look, please go to University Grants Commission and see that these regulations are amended. I am not saying that those who want to be appointed as assistant professors or associate professors or professors, they should not have this kind of a qualification. They should have, but at least there should be some regulations which allow senior members of the bar, very distinguished members of the bar, who are interested in legal education to become part-time lecturers. Unless we have this kind of a facility, we have a scenario where, like most of the law colleges, where the law management struggle to appoint the professors. I will give you one example. I gave example of the oldest law college in India, the government law college in Mumbai. For 12 years, with so many advertisements, we could not appoint a regular principal. And we were faced with such a situation that we used to depute our senior district judge to act as the principal of that great institution. Because we don't get law teachers. Maybe these qualifications may be issued, or maybe in Mumbai there were other problems like people found it difficult to secure accommodation, etc. But in future now we have to seriously consider whether we can amend the UGC regulations and allow senior members of the bar whose experience will be extremely useful to the law students to contribute. Now, as far as qualifications are concerned, it is a domain of University Grants Commission. When it comes to standards of legal education, now we have the rules of legal education framed by the Bar Council of India. Now, in those rules, now there is a compulsory clinical course, and there the Bar Council say that the assistance of lawyers and retired judges can be taken to conduct those courses. One more serious issue which we have to think about in future, which I have always raised. We talk about legal education. Now, what is the object of education? one object of the education is you acquire knowledge, and one may not be intended to practice law, but nothing wrong if somebody feels that I must acquire knowledge. I want to know what are the laws, I want to study the laws. So this is one category of students will go for this law course. But majority of the students who are going to law course, they go with the intention of practicing law. As a layperson, as somebody who has worked in legal field for 40 years, I asked a question to myself. Yes, now in the new regulations, new rules of legal education, there is a compulsory clinical course. I also noticed from that there is one heading of moot court exercise and internship. And there is also one clause that observance of trial in 2 cases, one civil and one criminal. 30 marks are assigned out of 100. Now this comes under the practical experience training. I am referring to this for a different reason. We have best possible national law schools in India. There are private law schools. They are really imparting quality education. Take a case of Bangalore, for example. I asked a simple question to myself. A fresh law graduate of best possible legal institution comes out with his degree, goes to the bar council, takes his sanad. If he is told to conduct a simple trial for offence under section 279, or a simple trial of offence under section 138 of Negotiable Instruments Act, or a simple money suit based on a promissory note, will he be able to conduct the case? The answer is no. Compare this with the medical course. Medical course, the MBBS course, the student undergoes very rigorous training. He has to attend the clinics. So maybe after he passes out, he gets MBBS degree, does his 1-year internship. When he comes out, he will be able to deal with, he will be able to treat some smaller diseases like common cough, cold, maybe influenza. But he is capable of doing the work, capable of discharging his duties as a professional. This does not happen. I have been repeatedly talking to bar council. I refer to this observance of trial in 2 cases. If you are sending a student to a particular court for 15 days, I wonder how student is going to observe a trial, because the life of trials is long. Though section 309 of CRPC provides that once the session trial starts, it has to continue and end. That is not happening here. We don't live in an ideal world. So I don't know, 30 marks are given, observance of trial in 2 cases. Which trials the students observe? They are supposed to submit a report. By going to a court for 15 days, you are not going to observe the complete trial. We need to work upon this aspect. Maybe with the permission of the High Court or Supreme Court, we should record the proceedings of trial where very eminent members of the bar conduct the trials, or proceedings of High Court where very eminent members of the bar argue a criminal appeal or a civil appeal. And that can be really, those clips can be shown to the students. There is also a provision for internship. There are no guidelines for internship. What the students are supposed to do, if they go and take internship in the chamber of a judge, every judge gives them different kinds of assignment. There are no rules, there is no pattern. So we need to work on what is the meaning of internship, what they are supposed to do. Everyone deals with interns in a different manner. I have a different method. I make my interns study the files of the next day, they prepare their notes, and I choose few cases and I allow them to brief me. So I virtually give them the opportunity to argue before me when I am sitting in my home office. So this is one pattern, but there is no standardized pattern. And therefore we really need to work on these aspects. Therefore, in what manner we can improve our legal courses, our law courses, so that those who want to join legal profession, they should be equipped to start a legal profession. So many students are here. All of us were lawyers. My experience is the same. For 1 year, I could not understand what is happening in the court, though I was a student of one of the best law colleges. There is one suggestion which was made by a very distinguished judge. I attended one such workshop. He said that why there should not be 2 different categories of law degree courses. One for those who want to practice law, and the other for those who don't want to practice law. They are doing that course for different reasons, to acquire knowledge, to acquire additional qualification, whatever the reason. So, if you want to have very equipped lawyers to be created by all these law schools and law colleges, perhaps we'll have to think on those terms. It's for the academicians to discuss that. The other issue which you have to consider in future, Goa, I believe, has only 2 law colleges. Goa? 2 law colleges. Right. But if you go to the neighboring state of Karnataka or neighboring state of Maharashtra, you will find that in all major cities there are 15, 20, 25 law colleges. Talking about Maharashtra, every city, even new cities like New Bombay, have now 8 law colleges. So there are a number of law colleges which are coming, and the standard of education, they are all affiliated to different universities. The standard of education in each college, if you go to Nagpur, the standard is different. If you go to Bombay or Pune, the standard is different. Now, one very good experiment which is successful, that is, I think, in state of Karnataka and Tamil Nadu. Now, you know, in many states, there are state universities which deal with medical education. So, all medical colleges or paramedical colleges are affiliated only to that state level medical university. Same experiment has been done in Karnataka and Tamil Nadu, I believe in some more states, where there is one central university for the state, and all law colleges in the state are affiliated to that particular university. They are not affiliated to individual universities. That will perhaps streamline the quality of education in all the states. So there are issues and issues which require consideration. I am only flagging those issues as a layperson, somebody who is part of this system for 40 years. But I know that the view of academicians will be different, and we want them to express their views. And I am sure that there are teachers in law who are sitting here, there are principals of law colleges, they will also apply their mind. So I request Brother Justice Mahesh Sonak to share his views.
Honorable Justice Pope, thank you for coming to Goa, and thank you for all the passion you have towards this subject. Brother Justice Karnik, Devidas Pangam, our Advocate General, Dr. Rao and Dr. Krishna Swami, respected Vice Chancellors, President Jilman Kuel Pereira, Senior Advocates, my dear friends, and dear students. The expanse of law is so great that one never ceases to be a student of law. Each day, you only discover how much there was that you did not know. In a sense, therefore, legal education, or for that matter, any education, is a progressive discovery of the magnitude of one's ignorance. Therefore, I think we must all, as of necessity, follow Mahatma Gandhi's advice that we must live as if this was our last day on the earth, but we must learn as if we were to live in eternity. The concept note which was given to me by Mr. Pereira correctly flags the impact of digital revolution on the legal profession. The digital revolution naturally has not spared the legal systems and the legal institutions of which we all are but a part. One of the biggest challenges for the 21st century lawyer would be to embrace this digital revolution, but without abandoning the core values or the core fundamentals of our legal profession. The digital revolution has completely overwhelmed us. Unlike the agricultural revolution or the industrial revolution, the change that this revolution has brought about and is continually bringing about is neither gradual nor is it predictable. Coping with such immense changes continually taking place at a very great pace can be stressful, particularly to people like us who have already reached their 60s. Legal education will therefore have to equip the 21st century lawyers to cope up with such stress levels, constantly reinventing themselves and alternating between learning and unlearning. It was Alvin Toffler who said that the illiterates of the 21st century will not be those who cannot read or write, but those who cannot learn, unlearn, and relearn. Emotional intelligence must also be a part of the curriculum in the law schools. I think it is necessary. Yuval Noah Harari, in his 21 Lessons for the 21st Century, writes that from time immemorial, life was broadly divided into two complementary parts. In the first part, a person accumulates information, develops skills, builds a suitable identity. In the second part of his life, such a person relies upon his accumulated skills and evolved identity to navigate the world, earn a living, and contribute to the society. However, the immense and unpredictable changes coupled with longer lifespans will make this traditional model completely obsolete. Whatever you learn today becomes obsolete. So you have to unlearn, learn afresh, and so on. To give you an example, the debate about whether machines would render humans obsolete gained prominence in the 1980s at the onset of the digital revolution. At that time, one of the arguments against obsolescence was met with the example of facial recognition. It was argued that even babies are adopted to facial recognition, but the most powerful computers on the earth then available were not. Today we take facial recognition software almost for granted. In the 1980s it was said that no computer would ever beat a human at chess because it was purely a mind game. In 1996 itself, the IBM supercomputer Deep Blue defeated the world chess champion Garry Kasparov with relative ease. At least I knew Amazon's Kindle as a book reading apparatus storing several books digitally. But I did not know that Kindle is able to and constantly collects data from users while they are reading the books. It can now monitor which parts of the book made you read fast, which slow, on which page you took a break, and on which sentence you abandoned the book never to pick it up again. I now hear that Kindle is upgraded with facial recognition and biometric sensors to record which portion of the book made you laugh, which portion made you sad or angry. That means very soon the books will read you while you are reading the books. Now friends, please imagine the impact of such a software on the relation between, say, lawyers and judges. Imagine, for instance, the advantage to a lawyer who has access to information on those aspects of their pleadings or legal arguments that most resonate with a judge. Imagine if lawyers were to access information about the type of arguments that appeal to a particular judge, or the arguments which were carefully considered, pondered, or those which were dismissed without a hesitation. Friends, kindly note that algorithms are watching you even at this instant. They are watching where you go, what you buy, whom you meet. They are monitoring your steps, all your breaths, and all your heartbeats. They rely on the big data and machine learning to get to know you better and better. And once the machines get to know you better than yourself, they would obviously be equipped to control you and even manipulate you. There would be nothing much you could do about it. In the end, it is a simple empirical method. If the algorithms indeed understand what is happening within you better than what you yourself understand it, then the authority will shift to them. Analyzing a judge is no longer the stuff of some science fiction movie. I understand that in the US, there is already a software which analyzes the probabilities of the side on which a judge may lean regarding a particular issue, based no doubt on the data bank of previously decided cases, writings, speeches, life history, etc. Computers now not only have great amounts of data, but they have vastly superior ability to marshal and evaluate such data in a scientific manner. In short, Legal education will henceforth have to prepare the next generation to cope with challenges that they have never encountered before, such as super intelligent machines, engineered bodies, and algorithms that can manipulate your emotions with an uncanny precision. Friends, technology is great if you are clear about what you want in life, if you are firmly grounded in values and traditions. But if you are not clear, it will be easy for technology to take control of your life. With the pace at which technology is advancing, you might increasingly find yourself serving technology instead of technology serving you. Friends, have we all not seen several people on the streets glued to their smartphones? Have we not experienced genuinely smart law graduates even refusing to look at their acts, trying to understand what the section says, trying to interpret that section, but rushing to their smartphones to find out scores of precedents on that subject? Do you really think that they control technology, or is it technology controlling them? Friends, Martin Luther King, in a slightly different context, said in the early 1960s that our scientific power has outrun our spiritual power. We have guided missiles and misguided men. Therefore, whilst I do not dispute in the least the inevitability of assimilating technology in our lives, it would be a sad day if we were to mortgage our ability to think and our ability to make intelligent and sensitive choices to a machine or an algorithm. It would be a sad day if we atrophy our thinking faculties and wipe out completely the difference between a human being and a machine. I am conscious of the school of thought that argues that there is no harm if the humans cede their intellectual autonomy to technology. Perhaps the time may prove them right or wrong. All that I say is that these are matters which should be thought about, their pros and cons deliberated. These are not matters which we should accept without any discussions or discourses, simply because they are presently expedient. Friends, we may not be able to control the winds, but we can surely adjust our sails. As it is, we live in an age which is extremely proud of its machines that think, but extremely suspicious of humans who even attempt to think. Legal education must embrace technology, but it must not allow machines to rob humankind of its humanity. You may regard me as old-fashioned, but I do think that legal education will now have to go to the basics and re-emphasize that the practice of law is not a business, but it is a profession. It is a noble profession in which finer elements of public service, creativity, sensitivity, compassion, consciousness are not mere irrelevancies. This profession is concerned intimately with humans in flesh and blood, with emotions and psychology. The litigants and the briefs are not some raw material in an assembly line set up by a lawyer or a firm of lawyers. Therefore, personally, I am a little alarmed when fresh graduates speak about startups and marketing strategies. I may be wrong in my discomfort. I may be reeling under the influence of an outdated bias. I genuinely do not know. All that I say is that legal education must at least be alive to such concerns and address them and then move on. Gone are the days when legal education would bombard law students with loads of information or data. Their memory was put to test more than their capacity to reason. With the march of technology, that would be unnecessary and even superfluous. The focus must now be on principles. Not just existing and established principles, but if necessary, challenging the established principles and evolving new principles. The focus must be to encourage creativity and critical thinking. The focus must be to inculcate virtues of independence and courage. These are essentials to the making of a good lawyer. And I do not know whether technology is going to be of great help in helping the lawyers to cultivate these essential traits. It is only with the capacity to think clearly, independently, fearlessly, that a student will have a chance to sift, discern, and if necessary, reject ideas and ideologies that are perpetually inflicted by, say, mass media tools that are growing powerful every hour. A few decades ago, the world was at war against WMDs, weapons of mass destruction. Today, television, social media, or mass media have become the new WMDs, weapons of mass distraction, not destruction. Friends, the virtues of courage and fearlessness go a long way towards making a good lawyer. Courage is the greatest of all virtues, because if you have no courage, you may not have the opportunity to use any of your other virtues. It was Thomas Jefferson who famously said that one man with courage is the majority. Physical bravery is admirable in certain circumstances, but they say that physical bravery is primarily an animal instinct. Moral bravery is much higher and it takes courage. Friends, let me digress a bit, but I must say it today that right from the day I was appointed as a judge, Justice Oak, who is with us today, literally mentored me. He taught me as well as several other judges that he has mentored by his example. Justice Oak has several praiseworthy virtues, but one of the best virtues that appealed to me was his fearlessness and courage in the most of trying times. And let me tell you, friends, that there were several such trying times from which he triumphed with utmost grace and dignity. And what was important, without the slightest hint of any bitterness or rancor or acrimony. Friends, I always think that Josiah Gilbert Holland, who wrote his famous poem, was written to quit Justice Oak, and permit me to quote it. It says, "God give us men a time like this demand, strong minds, great hearts, true faith and ready mind. Men whom the lust of office does not kill, men whom the spoils of office cannot buy, men who possess opinions and a will, men who have honor, men who will not lie, men who can stand before a demagogue and damn his treacherous flatteries without a winking, tall men, sun-crowned men who live above the fog." Justice Oak, I do not know in Delhi whether you can, in Delhi today we understand that it is very difficult to live above the fog or the smog. But we are very proud that Justice Oak from our court has lived up to these lines which Josiah Gilbert Holland has written. And now it is imperative that legal education strives to create such lawyers and such judges like Justice Oak. These virtues of courage, honesty, free and independent thinking or creativity can never be outdated or outmoded. They will remain, or must at least remain, essential attributes of a good lawyer, unless of course we collectively decide that legal practice need not continue as a noble profession, but it can very well be accepted as a business or a money-spinning venture, where unfortunately a different set of ethics can be applied. Therefore, legal education, even for the 21st century lawyers, must, while equipping such a lawyer with all the boons of technology and globalization, strive to see that such lawyers remain anchored to values, core values, and virtues that are essential attributes of a good lawyer. These views may sound outmoded, sentimental, and not world-wise. I do not wish to be judgmental, but all that I say is that do not make a hasty judgment. Do give these aspects the benefit of deliberation and even a debate. Then if they are to be buried, so be it. At least such thoughts would then have the satisfaction of a decent and a dignified burial. If I have sounded a little pessimistic, let me tell you that pessimism was never my intention. I am extremely proud of our digital revolution. I have no doubt that our generation next has a bright future and a capacity to make the future even brighter. We must look to the future because that is where we are going to spend the rest of our lives. I have firm faith in the virtues of humanity and humanism and the resilience of humankind. Some of the concerns expressed by me will cease to be concerns if we embrace technology with an open mind, but at the same time if we do not sacrifice core values like consciousness, sensitivity, professional ethics, creativity and courage. I thank the Goa High Court Bar Association for organizing today's function. They do great service by organizing such functions and the several functions that they have been organizing for the last few years. There is a complaint against those of our generation that we may not have left much of a future for our youth. That may or may not be correct, but such functions show that we are at least making an effort to prepare our youth for the future. The efforts of the Goa High Court Bar Association, the efforts that the Goa High Court Bar Association has put in to organize this program, and the very presence of Justice Oak and Justice Karnik in our midst, and the respected Vice Chancellors, despite their extremely busy schedules, is a sure testimony to this commitment. Thank you very much.
I request Brother Justice Makaran to say a few words.
His Lordship, Honorable Justice Abhay Oak, dignitaries on the dais, dignitaries of the dais, my dear young lawyer friends, law students, good evening one and all. When I was told about the topic for the symposium today, is Vadis, the way forward. Well, and when I came to know that there are so many young lawyers and law students present, so I thought this is the best possible opportunity for me to give you all a detailed lecture on this topic. But then I could have preached you so many things. But then yesterday in the papers I read that judges are not supposed to preach. So therefore, my entire exercise has, I'm in a bit of a problem. I can't offend the Supreme Court. Well, friends, let me say this. We heard the erudite speech of Justice Sonak, and I completely agree with what he said. I may not be able to say so many things in the same tone and in such a well-said manner, but I try to put it in as rustic way as possible, in my own words, my own personal opinions and no preachings here. Well, to make my point, I may have to go back in the past history, because we are discussing the way forward into the legal education. So we cannot forget what the past has been. Well, it all started like this, that I look at it like this, that the dispute starts when two persons are fighting. Both of them say I am right. Now the law students are here, so I put it as simple as possible. So they say I am right, he says he is right. Now who's to resolve this? So in olden times, these disputes would go to the king, who was the monarch then. And he had this big darbar where he used to sit on a mighty throne, and it was placed high up, the pedestal. And he would listen to the grievances of both the sides. Both the sides trusted him. They had faith in him. And ultimately, he would decide who is right and who is wrong. They would gladly accept whatever is right, whatever is the decision. Over a period of time, the responsibilities of the king increased. And therefore, slowly the system of courts came up step by step. And then we have this system where the judges still sit on the high pedestal. This to uphold the majesty of the law. And there is a purpose behind it. When two parties come, later on due to the complexities of so many matters, when two parties come before the court, the parties and persons were unable to put forth their grievances, sometimes due to illiteracy, sometimes due to the complexity of the matter, and therefore they had to engage counsels, legally trained counsels. Now these councils owed a duty to the court. They had to be abreast with what the law is. They had to make their submissions in a manner which behoves a counsel of that court. And that is how the practice of presenting submissions by the lawyers before the judge, respecting the courts, respecting the majesty of the court, it all started. And the judges, then and even now, the people have immense faith in them and started accepting their decisions. This is of course subject to the hierarchy of the courts when we have appeal, then we have at the last pedestal, the Supreme Court. So this goes on for some time. Now all this is all about an open court hearing which has been going on for times immemorial. Now a time has now come whether we should tinker with this system. When I say tinker with the system, and here I completely agree with what His Lordship Justice Sonak said, we have this practice of an open court hearing. Now today for convenience, of course during COVID times and all, we did face a lot of problems. And for convenience, we have the facility of a video conference. And therefore, because it is convenient for the lawyers, they would appear through video conferencing. But the question is, are we really doing justice to a client by appearing through video conferencing? The reason is this. I'll put it as simple as possible. Well, there's some misunderstanding somewhere. Take a case where there's a misunderstanding between two friends. The friend will go to another friend and say, why do you have a misunderstanding? And he'll try to convince him that please try to hear me out. This is the reason what happened. Without hearing me, without doing anything, you have formed an opinion about me. Please don't do it. This is what it is. And then the friend will say either he'll be convinced or not convinced. But he has that chance, and this is called a very important concept called as an opportunity. Every person has a reasonable opportunity of presenting his case. And there is nothing more important than a personal opportunity. So this happens best when you are in a court of law. So I would implore all young lawyers, before you adopt to this video conferencing facility, please try to come to the court as far as possible and make out a case. It helps you better. It even helps the judge understand the case better. Of course, in a given case where it is impossible for you, you may resort to the facility of a video conferencing. It is there for all of you. It is for convenience. Now, the video conferencing is really working. But for whom? Now, the lawyers have gone through the grind of a lawyer. They have been part of chambers. They have been trained by their seniors. They have seen what law practice is. And thereafter, when the time came, they could easily adapt to video conferencing. But so is not the case with the young lawyers who are yet to be trained in all this. And here comes the importance of a bar room, which I find is slowly and steadily, even in the Bombay High Court, where I'm a product of the appellate side, and so is His Lordship Justice Oak. We take pride in saying that we are products of the appellate side of the Bombay High Court. Now, what happens on the appellate side? What happens in the bar room? Bar room is a place where we get to rub shoulders with all the senior lawyers who are sitting there. And it is there that the senior lawyers watch your conduct. They watch how you are doing in the profession. When you are in an open court hearing, there have been times as junior lawyer when I have faltered so many times, and even thereafter. I must give you an example where I was appearing in one matter before Justice Doda, and he was hammering me left, right and center. Fortunately for me, one senior lawyer of the Bombay High Court was sitting next to me. He was pained by what was happening. And during lunch recess, he came up to me and told him what is happening is not correct. And he gave me that confidence. He told me these are the submissions you have to make. Please make your application in this particular form. The senior happened to be Justice O. Now this is what happens in an open court hearing. I'm sure your Lordship will remember that incident. It happened in courtroom number 40. Had it been a case I had appeared through video conferencing, where would that have left me? No senior to guide me, nothing. I would just have argued in the camera, blabbered a few things, taken a hit from the senior judge, and that is it. But then in the afternoon, suddenly the tables turned and the judge could see my point. That is because we got that assistance. Now this is what happens when you are in a bar room there are seniors who will always see, they will ask you, what are you doing? What are you reading? You can go up to them. Now what happens when you all have your swanky offices? The seniors are in their offices, they are comfortable attending through video conferencing. Where does it leave the junior lawyers? This is where I am really concerned with. And when you bring in technology, the technology has to be only after you are well trained as a lawyer. This is what I would like to emphasize, and therefore I would urge that before you adapt to technology, please adapt to technology. But before that, first inculcate the best practices of this profession. Now I'll give you an example of, and I'll join issues with what His Lordship Justice Abhay just said about the great legendary Mr. Nani Palkhiwal, about his qualifications. Now, do you need to be highly qualified for delivering justice? According to me, for the purpose of delivering justice, one must have a robust common sense, which is not very common nowadays. Now, there was this Chief Justice of India who thought I must have a feeler of what happens at the ground level. So he thought that I must go around the villages and see how the justice is being dispensed with at the village panchayats by the panchayat. So he went to one particular gram panchayat and he saw the sarpanch of that village. He was resolving the disputes within no time. The Chief Justice said, well, they have tremendous faith in this sarpanch. So he said, this sarpanch is very honest, his word is respected, and he is very fair. These are the attributes of a judge. And then next point he said, but he has nothing with him. So he said, that is the reason why justice can be dispensed with so fast. Because he doesn't have statutes, he doesn't have rules, but he has robust common sense with him. And he has that independence and he has that fairness in him. These are traits and attributes of a good judge. Well, as lawyers, you have all these statutes, all the rules, everything with you. Please be abreast with all the facts. In the morning, all of you must have heard His Lordship Justice Oak speak about how the lawyers should train themselves, the young lawyers should train themselves. And this is where we have to inculcate these best practices in us as lawyers before we really venture into this adventurism of technology. When I say this with a full sense of responsibility that something that has been gone on in open court hearing for times immemorial should not be tinkered with, and the very foundation of this system, getting disturbed in the process. We must think about this for the future as well. Bring it very slowly as possible. Now, since young students are here, I would just like to, drift away slightly and put something to you. Please treat this as an exercise. When as lawyers, you have to, one, you have to think on your feet, as Justice Oak had said in the morning. Secondly, you have to look at the matter from different dimensions. There are n number of dimensions of matter can be looked at. Now, from the social perspective, I would present one case which was, it is a case which was argued in the Bombay High Court. The facts were somewhat like this. There was a very good family, a family comprising of a husband, wife, and a child 8 years old. Now the husband would go out for work in the morning, come back late at night. Sometimes he would be away for 3-4 days. Unfortunately for the wife, she developed a fondness for a neighbor with whom she had an affair. Now, one fine day when the husband was not there, the neighbor, the wife, and the son, they went to one park. And at the park, the son saw something. Now, the son was very disturbed. Now, seeing that, both of them panicked suddenly. And to save himself, the neighbor, he killed the son, then and there in front of the mother. The mother became unconscious. Now, after she becomes unconscious, the neighbor runs away. The police come, investigation starts. Then the mother gives a statement, this is what has happened. The neighbor is arrested. Over a period of time, what happens is, the parents of this lady, they desert her, saying that you have taken away our grandson from you, you are a wretched lady, and henceforth we have nothing to do with you. Now the man is inside in jail. He sends a message, look here, there is nobody to look after you, I am the only one. So now what you do is, you turn most time. Now she is in a position where she doesn't have anybody to look after her. he is taking the advantage of this situation. The parents have deserted her. Ultimately, she goes to the court, helpless lady goes to the court and turns hostile. She says there were some other persons also, and this gentleman was always with me. There's nothing he has to do with this woman. And he walks away scot-free. What I want you all to think in this is, who is right in the process? Is this lady who deposed against her own son is right? Are the parents right who deserted the lady when she wanted her most, when the daughter when she wanted the daughter when she needed the parents most? Or is it the husband who influenced her? Is it the society which didn't protect this? This is something as law students you have to think about the matters from different dimensions, and this is what the beauty of this profession is. And therefore, though there are national law schools, you will get good pay packages, you will all be immediately engaged in corporates. I would implore and urge you, please come to this profession. This profession is very dynamic. There's a liveliness every day. You can do a lot for the society, and the future has a lot in store for all of you. There's ample space for all of you. With this, I conclude and leave it to this doctor. Thank you so much.
I request Mr. Devidas Pangam, Advocate General, to express his views.
Good evening to all of you. Today for this symposium amongst us, we are privileged to have the Honorable Supreme Court Judge, our own High Court earlier Judge, Sri Abhay Oak. We are very proud of him and we really cherish him as a judge of the Bombay High Court. We have Justice Mahesh Sonam, whom we all know very well. We have Justice Karvi, who has recently sat here and did a wonderful job as a judge. Mr. Rao, who is the Vice Chancellor of ILR. Mr. Krishna Swamy, who is the Vice Chancellor of the National Law School of India University. We welcome all of you, my senior members of the bar and dear colleagues, the students who are present here, and all of you. Today we are here to discuss a topic which you all know now. I don't have to introduce that topic. I have brought a written speech. Please allow me to read that. Friends, India is a major player in the ever-changing global economy. Due to the increased development of communication and travel, the world has shrunk. The interdependency and interconnection between all nations has increased, resulting in world being termed as a global village. In such changing times, it is necessary for lawyers to be able to adapt to the ever-changing international political, environmental and economic scenario. Today we are here to address a topic of paramount importance in the rapidly changing landscape of our world, that is the impact of globalization on legal education in India. The process of globalization has ushered in an era of interconnectedness where borders are no longer barriers and information flows seamlessly across continents. In this context, the field of legal education in India has witnessed significant transformation, both in terms of challenges and opportunities. Globalization has brought about a myriad of changes, influencing the legal landscape in profound ways. The interconnectedness of economies, the rise of multinational corporations, and the increasing complexities of international transactions have created a demand for legal professionals with a global perspective. As a result, legal education in India has had to evolve to meet these changing demands. One notable impact of globalization on legal education is the shift in curriculum design. Recognizing the growing importance of international law and cross-border transactions, law schools in India are adapting their programs. For instance, institutions are introducing courses in international trade law, transnational litigation, and comparative legal studies. These initiatives ensure that students develop a comprehensive understanding of legal principles that extend beyond national jurisdiction. The growing significance of intellectual property rights in the global arena, the rise of digital technologies, and the ease of information exchange have made protecting individual property a critical concern. Legal education in India is responding to this by incorporating specialized courses in intellectual property law, including global perspective on patents, trademarks, and copyright. The advent of technology has revolutionized legal education by breaking down geographical barriers. Virtual classrooms, online resources, and collaborative platforms enable Indian law students to engage with leading legal scholars and practitioners from around the world. Platforms like massive open-line courses, initiatives like Global Legal Information Network and Legal Information Institute provide Indian law students with access to an extensive repository of legal information from around the world, enabling them to develop a truly global mindset. However, the impact of globalization on legal education also poses challenges that cannot be ignored. The rapid pace of change in the global legal landscape, like the complexities of the international trade agreements and the evolving nature of the cyber law, demands continuous adaptation. Legal professionals must be equipped to navigate these dynamic changes, prompting educators to rethink traditional teaching methodologies. The Constitution of India also gives importance to the international law and international conventions. The directive principles of the state policy in Article 51 provides for promotion of international peace and security. It fosters international peace, security, as well as respect for international law and treaty obligations. It also encourages settlement of international disputes by arbitration. Further, Article 253 provides for legislation for giving effect to international agreements. It gives exclusive legislative competence to the Parliament to make laws to enforce international treaties and agreements, even in the matters concerning List 2 of the Constitution in the 7th schedule, that is the state list. In Vishaka versus State of Rajasthan, the Honorable Supreme Court held that international convention and norms were to be read into fundamental rights in the absence of Indian laws governing the field. Even in certain cases pertaining to recognition of rights of persons with disabilities, reliance has been placed on international conventions, such as in the case of Jiza Bose versus Union of India, where a differently abled person was forcibly deplaned. Lawyers nowadays are called upon to interpret laws which give effect to international treaties, to defend international commercial arbitrations, etc. Therefore, incorporation of international law into curriculum is conducive to the growth of young lawyers. Now we shall deal with few issues with the legal education system in India. The first issue I would want to raise is the antiquity of syllabus. The syllabus in the law colleges must be revised and revamped to bring it in tune with the requirement of time. Such syllabus must include matters concerning not only domestic laws but also international law. The syllabus should include learning of more technological know-how required for practicing. As we are aware, the modern electronic and information technology has taken over the functioning of justice delivery system. It is apt that the students are more equipped with modern technological know-how. As India emerges into economic superpower, the legal profession must be faced with all modern ideas and technology. The syllabus in the law colleges, therefore, have to be futuristic and must be accordingly prescribed. The next issue, which is most crucial, relates to teaching faculty. Colleges need to create an environment which attracts Indian scholars to the law colleges. This can be done by providing financial incentives, etc. There is a dire need for an excellent faculty which keeps up with the changing times. A faculty which preferably has some experience in litigation, drafting, or some other field of law, so that their practical experiences can be shared with the students, thereby enriching them. The third critical issue is practical training. In certain colleges in Goa, a 1-month internship with an advocate or a firm is prerequisite for the purpose of clearing the course. Only a month internship where the students are required to document the cases they have followed during that duration. Such practical experience is crucial for a law student to better understand the world they are about to step into. But the same is not entirely encouraged by the law colleges. Students should be encouraged to do internship for longer durations. Students also should be encouraged to do internship with judges as well. Students should be permitted a leave of absence in order to have an effective internship, as in several cases the colleges do not cooperate with the students on this aspect. Attending court hearing at the trial courts as well as the high court should be encouraged. Tie-ups can be contemplated between the state legal services authorities and students of law colleges to assist the advocates who are doing free legal aid matters in terms of research, etc. Lawyers are professionals and law colleges craft the professionals. Therefore, students that pass out as professionals should be equipped like any other professional to face the legal world. The fourth issue of utmost importance for lawyers is drafting. The basic training of drafting and pleadings, which is provided in law colleges, more often than not is provided by the teaching faculty, which has no practical experience of drafting pleadings or any document. Training when it comes to drafting of basic pleading and basic documents ought to be ideally carried out through practicing advocates and not by the teaching faculty of the college, unless, however, the said teaching faculty has past experience in the said field. Another pertinent issue we need to deal is the antiquated examination system. The entire examination system is based on rote learning. In order to obtain the minimum passing marks, the students handpick the selective chapters, topics, and mug up the same. The exams held in several law colleges are not problem-solving oriented. Marks should be awarded for application of law to a given hypothetical situation by a student. Debates should be encouraged and also be added to the marking criteria. Debates, after all, help inculcate the mind and open students to different points of view. There needs to be an overhaul of the entire examination system. In addition to the above issues, two general issues I want to raise today. That is, there has to be uniformity amongst the law colleges across the country. And the second issue is the mushrooming of our private law colleges. There is no uniformity in curriculum that is being taught to the students across the various law colleges. For that matter, there are a lot of differences between law colleges itself in terms of their teaching and the general environment of these colleges. With regard to the mushrooming of private law colleges, there are several new law colleges that have been set up in the recent past. This manifold increase in the number of colleges is a product of commercialization of the education. There has been an overall drop in the quality of legal education being imparted in light of number of colleges that have mushroomed. This called for an increased regulation and supervision of the colleges by the Bar Council in order to maintain the standard of legal education. These are few issues which came to my mind concerning our legal education, and I got an opportunity to share them with you. However, I must add that efforts are being made by various stakeholders, including the government, legal professionals, and academia to address these challenges and enhance the overall quality of legal education in India. Ultimately, legal education is a continuous process, but it is for us to ensure that we provide students with the basic requisites to flourish in the profession for betterment and growth of our society. With this, I thank all of you. My special thanks to the Goa High Court Bar Association for affording me this opportunity. Thank you very much. Jai Hind.
Thank you, Advocate General. In today's function, we have made a departure from the protocol, and we have two very distinguished academicians at the end. The reason is that they are the most important speakers today, and we are expecting a lot from them because both of them have done great work in the field of legal education. Only 3 or 4 points I request them to address. One is what Vadis said, that some law graduate telling him that he is going to have a startup. In fact, when we had recently convocation of Maharashtra National Law School at Aurangabad, at least 6 students told me that I went to convocation in one of the law schools in Indore. Same was the thing, that they said that we are going to start a startup. So whether our young law graduates are treating profession as a business, that is number one. Number two, of course, you are bound to say what is going to happen in future. But one issue was flagged by my colleagues, Justice Sonak and Justice Karnik, about use of technology. They talked about use of technology in court, but now we are eager to hear about the use of technology in legal education. I was the one, I always batted for use of technology in the court. But I always feel, which I have said on public platforms, that use of technology gives lot of ease we can work with ease by use of technology. But use of technology is per se not sufficient to improve the quality of justice which you render. For improving quality of justice which you render in courts, something more is required to be done, not merely use of technology. In the same way, by using technology in legal education, are we really going to improve the quality of legal education? This is one of the issues which we have flagged. So I request Dr. Rao to discuss.
I'll straight away take up the issues which have been raised by Lordship, because time is our relentless enemy. But before that, let me congratulate the elder person from Goa Bar for having taken such a wonderful initiative. Why not, they came 2 months ago to Euler, Goa to have a discussion threadbare for more than a couple of hours on the modus operandi, including the title Quo Vadis. And they have taken the initiative to organize a program on a day which is just 24 hours before the 75th anniversary of the Universal Declaration of Human Rights. Tomorrow we are going to have Human Rights Day. Quality legal education is the best guarantor of protection of human rights. This evening we are going to have the second works of quality legal education. The second issue is, my Lord was referring to Mani Palchiwala. It was on 11th December 2002 that Mani Palchiwala completed his voyage on this planet. Just 48 hours before that. And what a way to celebrate, those 2 things by having this wonderful seminar, sir. My grateful thanks to you. Straight away going to technology, I am reminded of Steve Jobs, who said just before his death, how happy and peaceful was life when Apple and BlackBerry were just fruits. Clearly sending a genetic signal that technology need not dehumanize. Technology has shortened the distances, but remember, the human relations have been stretched. And my question to my friend, I also belong to National Law School family, is in the 25 national law schools we have, are we robotizing the youngsters? Are we desensitizing them? Forgetting that human beings care more for longings than belongings? Are they becoming robotic in the process? Intellectually stimulating, yes. Professionally competent, yes. But what about human values? Where are we going? That is one spectrum of legal education. Islands of excellence, 25 law schools, excellent private institutions. To the other extreme, you have 1,700 law schools. I would never agree with anyone of you if you say the standards of legal education have gone down. They have increased. There is no doubt about that. Youngsters, especially my student friends, please remember, legal education in India has gone through 5 generations. Prior to 1961, when the Advocates Act came, legal education was totally elitist in character. It was accessible only to, as people used to say, Bengali Bhadralok people. People from rich people, communities used to go to places like Delhi, Bombay, Madras, Pune, if not London, to do the Bharat Law and come back. You had the genesis of democratization of legal education in 1961 when the Advocates Act was given to us. But in the name of democratization of legal education, pendulum was swung to the other extreme. Remember, law colleges of all hues and character emerged. To such an extent that Anil Diwan, father of Shyam Diwan, while addressing the law students in Bangalore, said, "It was very difficult for me to get a matrimonial alliance because I was an advocate. Nobody was prepared to offer their daughters to us." And Shaklavar was on record stating that India had the tradition of producing brilliant lawyers in spite of law colleges and not because of law colleges. A Daktari, a Parthiwala, a Shaklavar was an exception. So when there was an increasing concern for the quality of legal education and poor delivery system, a star was born in Bangalore, a jewel in the crown of legal education called the National Law School of India University. That was in 1986. That is the third generation, I say. But National Law Schools were also branded as elitist. In 2010, there was a total change, thanks to an initiative taken by late lamented Shamnath Bashir. I would say fourth generation of legal education. The idea came into the school, increasing diversity in admissions. And a semblance of equity started emerging in law schools. Sudhir Krishna Swami would be in a better position to explain to you as to how that is going. And after 2010, you have the opening of advocates from across the frontiers. Therefore, the Bar Council of India has again taken the initiative to start an institution of international character in Goa, thanks to the cooperation of the Advocate General, Judges of Supreme Court, and the Chief Justice. And this is how legal education has meandered in pre-independent India and the post-independent India. But my point here is, if you want the future of legal education to be safe, you should not miss the wood for the forest by focusing only on national law schools. Remember, the real India is in Bharat, where you have 1,700 law colleges. And my appeal to bar councils is, please take the initiative of convening such meetings with the principals of such colleges and find out what are their needs. What is the curriculum that they require? What is the point in teaching intellectual property law to a tribal from Chhattisgarh? What is the point in teaching patent law to trial court advocates? 90% of the trial court advocates, they deal with different matters. Now, bar council should take the initiative and should tell us that this is what we want for the future of legal education. And my lord was raising a very important point about teachers. And Advocate General was referring to syllabus. My humble submission before the House is, the job of a teacher is not to cover the syllabus, but to uncover the syllabus. To remove the cover of darkness, quo vadis, from here to eternity, from ignorance to knowledge, from darkness to light. Where are those teachers? Please tell me. Are the present-day teachers too self-centered with an enlightened self-interest? I'm asking. Youngsters are like liquids. They assume the shape of the container. They don't have any shape. Are we providing a shape to them? Are we self-centered? Are the teachers more bothered about income and not about outcome? No, because this is an honest forum to do self-introspection. I've been in teaching professions in the last 48 years. I was never in litigation side, but sometimes it's me. Okay. Why do you blame the youngsters? What is the value system that we are transmitting to them? Academic excellence, yes. But where is human excellence? Academic excellence without human excellence is disastrous. when the fundamental duty says to strive towards excellence in every sphere of activity, so that the nation constantly rises. What it means is not excellence in the product, but excellence in the human being. After all, Swami Vivekananda said, education is that bridges the distance between a human being and being human. And how many law graduates are being human? Does the fault lie in the system? Does the fault lie in the teachers? Let's make it clear. This is what you mean by quo vadis, where are you going to live in education? So focus, my friends, youngsters, on the 1700 law colleges and remove the robotic edges. Please recall what the Davos Economic Forum President Klaus Schwab said at the beginning of the Fourth Industrial Revolution. With that I will conclude. He said we are in the age of Fourth Industrial Revolution. The Fourth Industrial Revolution is a systems revolution and not a product revolution. You have robots, you have Internet of Things, you have artificial intelligence. But a robot can replicate your brain. But can a robot replicate your soul, which is full of creativity? Can a robot replicate your heart, which is full of passion and compassion? And therefore, what we require at the end of the Fourth Industrial Revolution is a new human renaissance. If we do not have a new human renaissance, we are going to be dominated by technology. That was the fear that was expressed by them. And if we are going to be dominated by technology, remember, chalkboard is just an illustration. It is just a beginning. And therefore, let the powers that be, let the persons who are in charge of legal education bestow attention on these areas so that the surroundings around us would become more safe, secure, just and equitable, because legal education enables us to develop the culture of having rule of law as a way of life. And that should be the ultimate goal. Thank you very much for listening.
Very well said. I request now the professors to brief questions on you. Yes.
Good evening, and thank you for the opportunity to be a part of this distinguished panel today. I'm here because of the initiative of the Goa High Court Bar Association Senior Advocate Pereira and Advocate Akash Ribello invited me, and I'm glad that I accepted the invitation and to join this panel. As the last speaker on this panel, let me just begin by trying to quickly summarize what my fellow panelists have said, and then go on to say a little bit about the main theme of this session, and I'll try and do this quickly. You've been a very patient audience. So Justice Folk began by focusing on the relationship between skills and legal education. And I think that in the context of the advocacy training workshops that were organized this weekend, that might be a suitable theme that I will focus on for much of what I will say this evening. Justice Sonak focused on the effects of technology on legal education. And Justice Karnik, I thought, made a nuanced plea to be over-reliant on technology in the courtroom and sort of not losing our bearings on core legal skills. Mr. Pangam focused on the effects of globalization on legal education, emphasis on pedagogy and curriculum, and raised several concerns about examination, curriculum design, and so on. And Professor Rao, among other things, focused on the need to democratize legal education across the 1,700 law colleges in India. So Justice Oka, before we just spoke, that's before Professor Rao and I got up to speak, suggested that we address two concerns. And I'm going to try and address those concerns briefly because at least what I prepared for. I tried to speak about something else. So I'll be brief in my response and then move on to the main part. On startups and students' career choices. I think that Professor Rao made the point that I would like to build on, which is that on average, I think we have to concede that our students are better educated and better prepared for a legal education than we were when we were students. So I think all of us, lawyers, judges, law professors, have to come to these questions with some humility about where the quality of legal education is today. Speaking for myself and for my graduates, I never second guess career choice. I think we have a role as educators to shape career choices, and our role ends there. For the most part, we assume that they know better than us. If startups are what they think will go out and change the world, we encourage them to do so. We don't second guess that. I don't see that as a commercialization issue. I see it as a career choice issue. If young people think that the world of technology and law is where structural change is going to happen, we back them on those choices. On the second question, on technology and legal education, I think we're much more schizophrenic. And I'll speak here as much for the National Law School experience, Bangalore, as for what might be happening across the world. I say schizophrenic because at times we engage our students intensely with new technology. For example, at the National Law School, we train all our students on how to meta-tag artificial intelligence training databases, what fine-tuning is, and how they should think about machine learning and the new technology in the field. And we expect that every one of our students will graduate with a fair understanding of how these technologies work. At the same time, we also run sessions where we have no technology in the room. We run a lot of assessment exercises, our examinations, our closed book pen and paper exercises, no technology whatsoever. Even on some of our research assignments, we have very strong restrictions on the use of technology, including generated text engines. So we are slightly schizophrenic about the place of technology. I don't think that educators can not engage the new technology. We would be failing our students if we didn't engage the new technologies. At the same time, we are aware that human capacities extend beyond the technological modes that they are exposed to, so we ensure that we break away from it. So I'm going to just stop there with those two brief responses and then move on to actually focus on what Justice Oak focused on, which is the place of skills in legal education. And I want to spend a little bit of time speaking about it in a way that I hope that the students in the audience who showed up in large numbers and have been more patient on a Saturday evening than I can expect from my own students, that some of these remarks might be useful for your legal education. The title of today's seminar asks us, where are we going with legal education? In order to clarify where we are going, it might be useful to ask, where are we coming from? And that question is just not a rhetorical frame. In 1992, a very important, arguably the most important report on legal education in the United States was written by Robert McCreight. It's called the McCreight Report of 1992 on legal education in the legal profession. McCreight framed the choice and the problem of American legal education to be that it was too theory-oriented. And he suggested that a practice-oriented legal education was necessary to rescue American legal education. Why should we pay attention to the McCreight report? And I want to say a little bit more about this. There's a lot more in it. It's a long report. I would encourage all students who are interested in the legal education that they're going to read it. Very readable, a quick read. It was rejected, that is the McCreight report, was rejected by the top law schools in the United States. And it was rejected because they rejected its core premise The core premise being that legal education is meant to train practice-ready lawyers. That our fundamental goal as legal educators in law universities is to teach proto-lawyers who could argue on day one, let's say, a small causes matter. I'll even lower the bar. And the assumption that was being made was contested and frankly just rejected by all the top law schools in the United States. They suggested that their role is to train lawyers to engage in conceptual analysis, to think deeply about the law, with the assumption that the law would not be the same even 5-10 years after they finished their law degree. And hence, what they needed to understand was concepts that they could use when statutory law and case law changed. This was the way they framed the project of legal education. What is striking, and other speakers on our panel have referred to this, is that the National Law School, which began in 1989, adopted the McLeod report. In 1992, Professor Menon, well before the Bar Council even began to change the curriculum for legal education, adopted mandatory internships, adopted drafting and advocacy courses, adopted arbitration and mediation clinics. This is in 1989. 1992 onwards, we tried to roll it out in larger numbers. And I think that we did this reasonably well as an institution. Now, subsequently, the Bar Council has made many of these requirements mandatory requirements in legal education. Some colleagues have referred to the 2014 rules, if I'm not mistaken, or the 2018 rules. I'm not sure the exact date of the legal education rules. But now all of these questions have been adopted. Currently, at NLS, we are engaged in the most comprehensive review of our BA LLB curriculum in the history of the university after its founding. Today, let me give you a sneak preview of how we are thinking about some of the core issues of curriculum design with a specific emphasis on the field of experiential learning, that is, learning towards the profession. And when I use the phrase experiential learning, I'm not talking about one kind of course or one kind of approach to pedagogy. I'm talking about all of these things, and let me explain. We already do internships, and the point of an internship is full immersion in the legal professional context. The point is not just to learn how to draft a particular plea or a particular memo, but how to imbibe the dispositions and the attitudes and the expectations of the profession. It is learning by immersion, right? It's as much about learning culture as learning language and skills. To internships, we have added the model of externships, that is, in-trimester externships in courts, in lawyers' firms, in practicing lawyers and with the AG's office in Karnataka. So we have put in place a new model of externships for credit, where students can learn through the process of immersion during their legal education. Second, we are focusing on clinics that are using live cases. So clinics tied to law offices, clinics tied to lawyers, mainly public interest lawyers across the country, working on live cases while you are in law school. Again, clinics for credit with clinic directors who have experience in the profession. Number 3, we're focusing on a range of simulation courses. And here with simulation courses, and I'm sure all of you in various law schools and the law students are already familiar with this, you do some MOOCs, you do some arbitration and mediation exercises, but what we are trying to do is to graft all of these into the core program of the university. What I mean by that is that every student, by the time they finish their second or third year at university in core courses on contract or crime, has already done
somewhere between 4 to 8 MOOCs themselves. This integration of moot court, arbitration and mediation simulation into core courses is central to the future design of how we want to reshape legal education. Skills courses on drafting and pleading as standalone courses are unattractive. They do not work. And so we are very keen to find ways of bringing skills back into the core curriculum, not leaving them as standalone courses, which I trust that many students in this room will agree are courses that are either very weak courses or courses that they quickly ignore and move on. I want to focus on a little bit on how can we teach in these experiential learning formats and reflect specifically on the Hampel method that is being used in the advocacy training program that was carried out this week. The Hampel method is seen as one of the leading pedagogical tools for teaching advocacy in the UK, Australia, and much of the common law world. What is the method? The method is modeled on a tutorial, so small sessions, maybe 6 students, 2 teachers or 2 facilitators, and a very intense exercise of modeling advocacy. That is, the student tries, the expert or the trainer responds, and then tries to correct one skill at a time. This model or this style of pedagogy is one that we are
more and more innovations and more progress, because as rightly said by Professor Rao, if justice delivery system in our country should survive and is to improve, we need best possible legal education. And therefore I always believe that we the judges and we the lawyers, we should be always looking forward to assist the academicians in the pursuit of giving us better and better legal education. Unless the members of the bar and members of the bench actively support our law schools and law colleges, we won't make any progress. And while I say so, I must say that we, the judges who are involved in legal education, maybe we are chancellors, we are pro-vice chancellors, chairperson of the various committees of the Executive Council, etc. We have to be very cautious in the sense that we should make our contribution without interfering with the work of academicians. They must be given full scope to excel in legal education. I again thank the organizers for this excellent evening. I believe that Goa Bar Association will continue such ventures, and I request the President to present a paper on today's discussion to the Chairman of Bar Council of India, because ultimately our job is to give them ideas. That they are the one who are controlling legal education apart from the University Grants Commission. So again, thank everyone for giving us this opportunity.
Any questions from the crowd, please raise your hand. We'll have the mic. Please be to the point in your questions.
While these ideas are very good, the point is, how can we also have a new education policy? And the new education policy requires that there have to be that many takers for a course, for that course to be conducted. So if you have courses on conceptual issues, for example, then if there aren't 60, as I understand now, then a lot of these things that are desirable will not. Is there scope for that? Or is there something that we have to do to input into the new education policy in terms of making changes in that, to ensure that there's a possibility of courses which are not some profit-oriented courses, because lawyers will, otherwise students are not going to opt for those, because they are looking at how can this benefit them in terms of their income or their policy interventions or anything like that. So how can that be worked? Because otherwise all these ideas will not materialize. All that has been said is what I think.
Yeah, thank you for that question, and I'll respond in two short points. The first is that the NEP, the new education policy, is in the form of a policy guidance to universities and to colleges, which may be implemented in various ways. So it's not in the form of a tight regulation or a stricture that only this or that can be done. So the way I look to the NEP is to look for guidance. But I wouldn't get fixed up on a 60% rule or something like that as being a restriction. Ultimately, the core of our curriculum, whatever courses we are teaching, must respond to what we think are the conceptual understandings and perspectives. And the perspectives are as important, perspectives on the world, that our students must be acquainted with. They may agree or disagree with what we present in class. That's completely all right. But they must become acquainted with these perspectives. This is the job for educators to do. This is our job. It's our job to frame the curriculum. I don't see the NEP as a restraint on that kind of design. And we should stick by our convictions and design curriculum to ensure that our students receive that.
I would add to what they have said. The core features of NEP for legal education are constitutional values of justice, must be competitive globally, and law must be taught in socio-cultural context, giving due importance to ethics and importance of public purpose, and it must involve critical and interdisciplinary thinking, and standalone universities should become multidisciplinary. These are the 7 points national education policy, and most of the law schools have already taken the initiative to incorporate these things. Okay. And they have started teaching law, focusing on constitutional values of whatever the advocate general says, justice education and not legal. Focusing on justice.
Madam Norma.
Yeah. So I have 2 comments to make. I don't expect an answer, but I hope you will consider. Just Sonak talked about courage and integrity being the 2 very important qualities that should be there in the lawyers. I really don't think that law schools can teach this when the entire education system bringing the child up to law school is to simply crush courage and crush integrity. Because you are not taught in the education system to be able to speak out, you are taught to give the right answers. And when you know that in law practice your job is to get your client off the hook, then integrity takes a back seat. This is my thoughts on this point. I do believe they are important, but I think it comes from somewhere else. Maybe your morality, your upbringing, or something else. But what I think law schools can teach is preciseness and brevity. I think that if you can teach students to focus or to be able to draft a brief which is precise, clear, to the point, perhaps that integrity will come in. Because very often when our own briefs, mine included, are pages and pages of stuff, and we flounder along trying to get a hold somewhere or the other in the case, hoping something will catch with the judge. You try your luck in many cases. But if you are really respecting integrity, then you must know what your point is. You must be able to say it very briefly. And if I add one more line, I remember a lawyer from the United States saying that in the Supreme Court, a brief should not be more than 15 pages long. They chuck it out if you do it more than that. In 15 pages, you must be able to say what you want, which is preciseness and a lead to integrity. That's my one comment. And the second comment, sir, I say with anguish, please don't take it badly, but it's important. I felt very unhappy that one half of humanity was not represented on the panel which I see in front of us. And I think we need to be represented there. I need these young students to know that women can also make that dais as well.
My apology.
We all plead guilty.
Forgiven, sir.
Oh, Vadis, we will say mea culpa.
I said so, sir.
So may I add one thing to that? Of course, I endorse what she says. But my question is, they've rejected the McRae report in America, but they adopted it in entirety in India. According to me, one of the fundamental premises on which it was rejected was that they are being taught the tools of the learning and not just the law as it is to be applied. So there has to be an integrated approach, according to me, that you teach them the tools of the learning because law is a living subject. The analytical tools are as much important as learning what has gone by in the past in order to develop the law in the future. Teaching them practicality is essential.
again, the essential analytical skills cannot take a backseat. This is what I have to say. Thank you.
This would be the last question.
Good evening. This is a doubt that has been festering in my mind ever since I've been listening to you, and I have to say it is a great honor. But I wanted to ask, almost all of you present over here had said that technology was one of the reasons as to why legal education might have a downfall in its future. I wanted to ask this: if technology is something that has, consumed us so much, then how is it that we are supposed to control technology in order to acknowledge the fact that yes, this has been an extremely addictive thing, and we have to learn from what we are doing bad, and we have to learn more regardless of our technology.
I don't think anybody has conveyed that use of technology in legal education is not welcome. Technology has come to stay. The technology has to be used. But we are more on the question in what manner we can use technology. What Brother Justice Sonak said, that if we want our students to interpret law, we should tell them not to use any software to interpret it. They must read the Ware Act and then apply their mind and start learning to interpret it. That's what we intended to suggest. Nobody said that technology should not be used in education. I again say on behalf of all, technology is bound to be useful. It is going to be useful, and it is going to be useful in education. In what manner we can use it, that is the main topic of discussion.
I will share, you are my parents student now, my experience with former students of National Law School who wrote me a mail after working in the corporate sector. I repeat from the letter, he said, if slavery anywhere exists in 21st century, it is in the cubicle confines of the law firms. And we are becoming mad because of excessive use of technology. Sir, please give me a reference letter so that I go for postgraduate studies. And I burnt out, he said. This is the word he had used. Then I said, you are getting burnt out because you are focusing more on mundane things, materialistic things. Technology never says that you focus only on mundane things. Remember what our former Prime Minister Vajpayee said in one of his Hindi poems. He said, Internet may be important, but internet is more important than Internet. And we are making our youngsters most disconnected generation in the name of connectivity. That's what he has said. That's what we never want. Because technology should be converted into a boon, should never be made a bane.
So let me try to respond to Aprupa's comment and the other comment about courage and integrity. So I don't think anyone on the panel was pessimistic about technology, and maybe, I don't know where panelists would fall individually, but I might be among the most optimistic of the members on the panel. I have no doubt in my mind that technology will fundamentally change legal practice, the profession, as well as legal education, even before you graduate. That is, he mentioned that you might be a first-year student or a second-year student. Even before you graduate, the practice of law will fundamentally change. And I've spoken and written about this elsewhere. I think most of us are sleepwalking into this transformation, and we would all do well to to engage it far more rigorously than we have done so far. But on the courage and integrity point, I don't think we can teach it in a curricular way, but we can teach it as a matter of example in an exemplary way. And I think this is the best that universities can do. That is, we set the right example.
Thank you to our panelists for expressing their views, also to the members here who put forth their queries. It's indeed been a very enlightening session, and I would also say a soul-searching session. So, but before we deliver the vote of thanks, we want to express our gratitude to all the panelists here, and especially to Justice Oak, the Vice Chancellors who've come all the way to attend this function. And why I make a special mention of Justice Oak is when we sent the invite, this whole thought came about 2 months back when we met Justice Oak in Delhi for a conference, and it was a brief interaction of 2 minutes, but that is not new to Justice Oak because that is what happens in Supreme Court. In those 2 minutes we only asked him that, sir, would you like to come to Goa, and we want to extend our invitation to you to please come to Goa and have a seminar with us. And in those 2 minutes, he immediately asked the dates. I still remember, and he said tentatively these are the dates, and he said if that is the date, I will come to Goa. And from then on, it was never a no. And then we sent a formal invite. The invitation was immediately accepted. Well, the acceptance came with a rider that no memento should be presented and will not be accepted by Justice Oak. We were worried that we may be hauled up in contempt. But knowing the love that he has for the state of Goa, we knew that we would find our way around this situation. And when we told him what is the memento that we intend to present to him, he immediately accepted that yes, you may please present it. Why we are indebted to Justice Oak especially is not only for the judgments, landmark judgments which he has delivered when he sat here as a judge of the Honorable High Court of Bombay, and what he has delivered now in the Supreme Court. The Bar of Goa also owes a great to Justice Oak, because, and sir, in a public forum we want to thank you. The subordinate court building which we see today is shaping up at Mercedes Complex. We owe our gratitude to Justice Oak because it was the judgment of Justice Oak which said that this building has to come up and it has to see the light of the day. And sir, we are happy to tell you that the building is indeed shaping up. A big thank you to the administrative judges here, the Advocate General for following it up, and in all earnest, we hope to inaugurate the building as soon as March or April 2024. We are moving in that direction, and we stand resolute to that commitment. So, to express our gratitude to Justice Oak and all the panelists, I request our President of the Bar Association to present them with a memento, which is a frame of Goddess Saraswati, and that is the reason why Justice Oak gladly accepted.
To quote the oft-repeated adage, all good things have to end, would aptly describe today's panel discussion. For this, we have to thank our esteemed panelists and speakers, His Lordship Justice Abhay Oak, Their Lordships Justice Mahesh Sonak, Justice Makarand Karnik, the Advocate General Mr. Devidas Pangam, Dr. R. Venkat Rao, and Dr. Sudhir Krishnaswamy. The discussion was both thought-provoking and enlightening. I am sure that not only the young lawyers and the law students, but all the rest of us have some takeaway from today's discussion and interaction. Thank you. Today's law students are poised to be tomorrow's lawyers and judges who would shape the destiny of the legal and judicial system in our developing and evolving nation. That only underscores the importance of legal education. On behalf of the Goa High Court Bar Association, I express a deep and sincere gratitude to His Lordship Justice Oak, His Lordships Justice Karnik, Dr. Rao, and Dr. Krishnaswamy for taking the time out to travel to Goa and participating in today's event. All of you must have a very busy schedule, and your presence today means a lot to us. Thank you once again. To the dignitaries of the desk, senior advocates and my colleagues, law students and friends, thank you for spending this evening with us and attending this event. To the trainers and organizers of the ongoing training program, we owe you a debt of gratitude. Our feedback of the program is that it's simply superb. That's what all the participants say. And I am sure that they must have gained a lot from the 1.5 day that has of this training program and the 1 day to come. Thanks a lot. Friends, we look forward to your presence at our next event. A special thank you to the High Court establishment for their assistance in making this event a success. I wish you all a pleasant evening and enjoy the weekend. Thank you.